Hello, mic check, 1 2 1 2. Let me know if you can hear me. I'm double checking before I continue because I will talk on mute. Okay, thank you, Bama girl. Quick greetings. Hey, Bama girl, Miss Cutie Pie, Sound Check Annette. How are y'all doing? I will have to catch up. I haven't gotten there, but if they pull a highlight, I'll probably jump out of order and do that one about Hilton today, Bama girl. Y'all, I'm only on I'm still finishing up Monday. Oh my gosh. Hey, Kim Green. Okay, hey, Bravo. So yesterday, the Supreme Court of Georgia, they did make a decision about Brian Steele, and what happened when Glanville put him in contempt of court when he said he would not reveal how he knew about the ex parte. um and so we are going to go ahead and just read the circumstances and their decision on here because that will be the best context. Good afternoon, Glow, Dana. Hello, hello. I'll be watching it. I'm trying to, well, I'll watch it. I'll watch it. I won't even say I'm gonna wait till I watch it in order. I'll just try to go to today and watch the end. That's what, cause yeah, I'll try to jump out of order and watch it. Hey, Auntie Natty, Sharon. All right, y'all. So let's get started on what the Supreme Court decided and why. Okay, so I don't know why I always put an E at the end of Brian Steele's name, because even in this title right now, I have an E at the end of his name, but it's Steele v. the State. Peterson, presiding justice. A trial court found attorney Brian Steele in contempt of court for refusing to tell the court how he learned about the court's ex parte hearing with a witness and prosecutors in a case in which Steele is representing one of the defendants. Steele appeals from that contempt order, arguing that the evidence did not support a contempt finding because he did not interfere with the court's administration of justice. His information was protected by attorney-client privilege, and due process required the judge to recuse from the contempt proceeding. Because the court delayed punishment, the alleged disobedience was directed toward the court, and the court was involved in the controversy that formed the basis of the contempt. Due process required the judge to recuse from the contempt proceeding. We therefore reverse the judgment of contempt imposed by the trial court. The record shows the following. Steele represents a defendant, Jeffrey Williams, in an ongoing criminal case charging multiple defendants with, among other things, participation in a criminal street gang and conspiracy to violate Georgia's Racketeer, Influenced, and Corrupt Organizations Act. In June 2024, Fulton County Superior Court Chief Judge Earl Glanville was presiding over the trial. During the trial, Judge Glanville found one of the state's witnesses in contempt for exercising his Fifth Amendment privilege against compelled self-incrimination, essentially refusing to testify, despite having been given immunity from prosecution. Judge Glanville adjourned the trial on a Friday and stated he would resume the trial the following Monday and asked the witness, outside of the jury's presence, whether the witness would testify. And a footnote says, although several of the defendants were charged with murder, Williams was not. The following Monday morning, Judge Glanville held an ex parte meeting with the witness, the witness's counsel, and state prosecutors and investigators to discuss whether the witness would testify for the state. The meeting, taken down by a court reporter and transcribed for the record, took place in Judge Glanville's chambers and comprised most of the morning, at the end of which the witness said he would testify. The witness gave limited testimony before a lunch recess was taken. Following the recess, Steele informed Judge Glanville that Steele had learned about the ex parte meeting and moved for a mistrial. Judge Glanville stated that he was disturbed because that is ex parte and repeatedly asked Steele to reveal the source of his information, informing Steele that if you don't tell me how you got this information, then you and I are going to have some problems. Steele refused to reveal his source, and Judge Glanville told Steele that it was disturbing that somehow you have surreptitiously gotten information in regard to the court's private ex parte conversation with a party. Judge Glanville repeatedly told Steele that he was going to hold him in contempt if Steele did not tell him who disclosed the ex parte meeting. Steele claimed that the information was covered by attorney-client privilege, challenged by Judge Glanville. Steele also said it was attorney work product. Judge Glanville then took a recess. Upon returning to the bench, Judge Glanville told Steele that there was only one way you could have gotten the information and that it was not work product. Judge Glanville again asked Steele to reveal his source and said he was going to hold Steele in contempt if Steele refused. Steele said he did not want to be held in contempt, and Judge Glanville responded, "I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious." Steele asserted that he could not comply with the court's order without violating Rule 1.6 of the Georgia Rules of Professional Conduct, which states in part that a lawyer shall maintain in confidence all information gained in the professional relationship with the client. Judge Glanville rejected this argument and stated, "I'm going to hold you in contempt and you can think about it," adding that at 5 today, we'll see where you stand on that point. Judge Glanville told Steele that he was not asking for the sum and substance of what was said, only for how Steele learned about the meeting. Steele responded, "I can't do that." Judge Glanville then told Steele, "I don't want to hold you in contempt, but this is that serious. You cannot eavesdrop and get information that was not meant for you to hear." Steele said he would do whatever you want me to do until 5 or thereafter, but maintained that the matter was serious enough to warrant a hearing and then moved for a mistrial. When Steele said he wanted to get to the substance of the ex parte conversation first, Judge Glanville responded that Steele would be in custody until 5 p.m. because you need to tell me how you got the information. There was a brief back and forth about how Steele possibly learned of the information and whether it was privileged before Judge Glanville said, "I'm not going to have any further conversation with you about this. I want to know, the question still remains, I want to know who gave you this information?" Judge Glanville then said he can go into custody at this point in time. Steele was not immediately taken into custody. He made additional arguments in support of a mistrial and repeated his argument that he could not disclose his source without breaching Rule 1.6. Judge Glanville told Steele that he could not hide behind Rule 1.6. Steele said he was not hiding behind anything and continued to ask why he was excluded from the ex parte hearing. The prosecutor then made several arguments as to why the ex parte meeting was not improper and why the information at issue was not protected by Rule 1.6. Steele's co-counsel then addressed Judge Glanville, informing him that co-counsel was also in possession of the same information Steele received and that the trial should not continue until the court resolved the ex parte issue. Steele's co-counsel renewed the motion for mistrial, which other defendants joined. Judge Glanville denied all of those motions and said he was going to proceed with the trial. Steele's co-counsel said he would not participate in the trial without Steele and without the court addressing the ex parte issue. Judge Glanville responded, "Sir, you all are getting yourselves cross purposes at this point in time. You made some things out of nothing. I think that you are on very precarious ground at this point in time." Judge Glanville said that he would continue with the trial and co-counsel could represent Williams. Co-counsel again asked Judge Glanville to address the ex parte issue, but Judge Glanville refused. Judge Glanville then ordered Steele to be taken into custody. As he was being taken away, Steele asked to say one thing, clarifying that Judge Glanville was denying Williams his right to counsel and again moved for a mistrial. Judge Glanville denied the motion and said the court was going to take a 5-minute recess. When proceedings resumed without Steele present, Judge Glanville ordered co-counsel to continue representing Williams and said co-counsel could consult with Steele on breaks. Co-counsel said he would not, although he respected the court has to do whatever it believes appropriate. One of the state's prosecutors suggested to Judge Glanville that he fashion a contempt punishment that would still allow Steele and co-counsel to continue representing Williams so as not to interfere with Williams' right to counsel. Judge Glanville agreed. Other defendants continued to press for a transcript of the ex parte meeting, refusing to accept the representations of the trial court and the state that nothing inappropriate happened. Judge Glanville responded that an appellate court could tell him if he was wrong and that there were other bodies in Georgia that could review his conduct. Judge Glanville then said Steele could return to the courtroom, took a recess, and following the recess reminded Steele that he was still being held in contempt and could purge the contempt if he revealed the source of his information. Judge Glanville told Steele that he would go into custody at the end of that day's proceedings if Steele did not reveal who disclosed the ex parte meeting. Judge Glanville then stated that he might make some other remedies depending on what information I find later. The jurors were then brought back into the courtroom and the trial resumed. At the end of the day, after jurors were released, Judge Glanville asked Steele if he was willing to reveal who disclosed the ex parte information. Steele informed the court that the Georgia Association of Criminal Defense Lawyers sent an attorney to represent Steele because the court accused Steele of eavesdropping, which is a crime. Judge Glanville informed Steele's attorney that he was about to enter an order of contempt, was offering Steele another chance to purge, and that was the only thing I'm trying to do at this point in time. Steele's counsel argued that due process required Judge Glanville to refer the matter to another judge since Steele was entitled to a hearing and Judge Glanville would be a witness at that hearing. Judge Glanville rejected those arguments, sentenced Steele to 20 days in jail to be served on weekends, and stated that Steele was not entitled to a supersedious bond. The written order reflecting this sentence did not provide Steele an opportunity to purge the contempt. This appeal ensued. Let me see the footnote. Okay, the footnote says Steele filed his notice of appeal in the Superior Court and an emergency motion for supersedious, and I'm sorry if I'm not pronouncing that word right, with the Court of Appeals, which transferred the emergency motion to this court. Hold on. I got to Google this word. Hold on. Hold on. Where is it at? I'm not afraid to use Google. Oh, hold on. Okay, we predetermined whether the matters fell within our jurisdiction over cases in which a sentence of death was imposed or could be imposed, and took the case under our. Oh, here's another one. Hold on. Y'all are gonna see. I'm humble. I will just Google the word. Hold on. Ooh, certiorari. Jurisdiction granting a writ of certiorari as to both the emergency motion and the appeal of the contempt order. The Supreme Court may review by, oh my gosh, let me have them say it again. Certiorari cases in the Court of Appeals which are of gravity or great public importance. All right, let me go ahead and do supersedious to see how do I say that word, because I might as well get all of the things. Oh, why? This one doesn't have a little speaker. Hold on. Okay, hold on, y'all. Sorry, we get educated. Let me see. Okay, supersedious. Okay, I had that one. Let me get back to see what y'all said. Okay. Oh, y'all ain't even. Okay. So we're good. We're still on track. Okay, that was all from a footnote. Okay, Steele challenges the contempt order on several grounds. We do not reach most of those arguments because we agree with Steele that to afford Steele due process, Judge Glanville was required to recuse himself. Our precedent makes clear that individuals facing criminal contempt are entitled to due process. This constitutional right to due process applies in criminal contempt proceedings because a conviction can result in the loss of liberty and the levy of a penal fine. What process is due depends in part on whether look at this. Today is the day. Hold on, y'all. Lord, I don't know why you trying me today. Hold on. This is not the time. Contumacious. What process is due depends in part on whether the contumacious conduct occurred in the court's presence and whether a court announces punishment immediately. When the contumacious conduct occurs in the presence of the court, a trial court has the power, when necessary, to maintain order in the courtroom, to declare the conduct to be contemptuous and announce a punishment summarily without further notice or hearing, so long as the contemnor has been given an opportunity to speak in his own behalf. Even where summary punishment for contempt has been imposed during trial, the contemnor has normally been given an opportunity to speak in his own behalf in the nature of a right of allocution. Ooh, let me get back. These situations are typically limited to conduct that occurs in open court because such conduct generally threatens the court's immediate ability to conduct its proceedings, such as where a witness refuses to testify or a party disrupts the court. Such summary proceedings are tolerated because of a trial court's substantial interest in rapidly coercing compliance and restoring order. If a trial judge was required to recuse or hold separate contempt proceedings every time a proceeding was disrupted, unruly litigants, lawyers, or members of the public would essentially possess a heckler's veto, and trial judges would have no way to restore order and proceed with the court in a timely fashion. The situation is different when the contemptor's conduct does not interfere with the court's proceedings and thus need not be punished immediately. In those cases where the court delays punishment or the conduct occurs outside the court's presence, more process is due. If the announcement of punishment is delayed, a court must give the contemptor reasonable notice of the specific charges and hold a hearing. If the punishment is delayed and the contumacious conduct was directed toward the judge, or where the judge reacted to the contumacious conduct in such manner as to become involved in the controversy, that hearing must be conducted by another judge. Here, Judge Glanville did punish Steele summarily for his refusal in open court to comply with Judge Glanville's order, as he held Steele in contempt, placed him in custody, and had him removed from the courtroom, but that punishment is not the subject of this appeal. Steele was allowed to return to the courtroom to continue representing Williams and was given until the end of that day to comply with the court's order. Judge Glanville made clear that Steele was still in contempt, but he did not announce what specific punishment he would impose. Because the announcement of a specific punishment was delayed by the trial court, Steele was entitled to additional process. In particular, he was entitled to have the matter heard by a different judge. Steele's repeated refusal to comply with Judge Glanville's direct order was conduct directed toward the judge. Steele continued to challenge the propriety of the ex parte meeting and asserted that he could not legally comply with Judge Glanville's order to disclose his source. The exchange between Steele and Judge Glanville makes clear that Judge Glanville was involved in the controversy. For these reasons, a different judge should have presided over the contempt hearing, and the failure to do so requires reversal. Reversing contempt order on due process grounds because contempt action should have been heard by a different judge, where announcement of punishment was delayed in allegedly contumacious conduct, and attorney's failure to stand and respond to the court was conduct directed at the judge, and the judge became involved in the controversy. Where a judge does not act the instant the contempt is committed, but waits until the end of the trial, on balance, it is generally wise, where the marks of the unseemly conduct have left personal stings, to ask a fellow judge to take his place. Judgment reversed, all the justices concur. All right. So, yeah. So it wasn't even just a majority. That was unanimous. All justices concur. All right, y'all. So that is that. Steele got his win. It was reversed, which it should have been. Glanville was doing a lot of wrong. But I'm glad, because honestly, had it happened during trial, I don't know if it would have been reversed, because they said their main thing is that the judge delayed the punishment and giving him a chance to purge and all that. And that was one of the main reasons they were easily able to decide he should have not been decided to be held in contempt by the same judge. So, but good for him. And I have to catch up on all the other craziness that's going on. But I thank y'all for stopping by. I will see y'all, of course, again this week. But I have to travel this weekend. So we might have to catch highlights only. Super, super highlights only this time. Yeah, very shiesty. I agree. Yeah, that's what it seemed like, Bonnie. That's what it seemed like. All right, y'all. I will see y'all later. Thank you for stopping by. Bye.